Get ready for the dictation. Start. The Learned Senior Counsel submitted that the said 1983 guidelines were also accepted by this court in the judgment of Dr. Kesav Rampal. The Learned Senior Counsel further contended that those guidelines were sufficient for the Commission to make the selection in the interview. As regards the composition of members, the Learned Senior Counsel contended that the High Court, having applied the de facto doctrine, there was no scope for the High Court to interfere with the selection. As against the above submissions, Mr. C.U. Singh, Learned Senior Counsel, appearing for the contesting private respondents, in his submissions while meeting the arguments on estoppel, contended that there were 16 writ petitions in which the division bench passed the impugned judgment, and therefore the withdrawal of two earlier writ petitions will not have any effect on this judgment. The Learned Senior Counsel also submitted that in any event in Bharat Singh's case, while issuing directions for the disposal of the writ petitions, this court observed that opportunities should be extended to all concerned, and therefore the present case is completely different one and not covered by any of the judgments passed earlier in order to apply the principle of estoppel. The Learned Senior Counsel also submitted that the withdrawal of the earlier writ petition was not with an intent of forum shopping, since that writ petition was filed at the stage when interview was not held, and since by the time the writ petition was taken up the whole interview was over, the writ petition was withdrawn and fresh writ petition was filed challenging the whole selection. The Learned Senior Counsel then contended that the High Court, after finding that respondents 4 to 9 had already ceased to be the members of the commissions, there was no scope to consider the prayer for quo warranto, and consequently applying the de facto doctrine made a deeper scrutiny in the whole selection and gave valid reasons for setting aside the selection. The Learned Senior Counsel pointed out that the grounds raised in the writ of quo warranto were very formidable grounds, inasmuch as the appointment of respondents 4 to 9 were not in accordance with section 4 2E or 4 2A G of the 1980 Act. The Learned Senior Counsel therefore contended that the course adopted by the High Court, in having made a deeper scrutiny and its findings on each one of the issues to hold the selection invalid, was well justified. The Learned Senior Counsel relied upon the decision in State of Punjab versus Salil, Savlok and others 2013 5 SCC 1. Mr. Jitendra Mohan Sarma, Learned Senior Counsel, who appeared for the petitioner in a writ petition before the High Court and who has filed IA number 15/2013 in CA number 3361 of 2015 for intervention submitted that when the whole process of selection was challenged, the consideration of individual cases is of no consequence. Stop. The learned senior counsel pointed out that when the term of invalid members, viz., respondents 4 to 9, before the High Court was over, the High Court was not in a position to deal with the issue of quo warranto, and consequently it made a thorough examination of the process of selection as to its validity and found the same to be wholly invalid for setting aside the same. The learned senior counsel placed reliance in Union of India and others versus O Chakradhar 2002 3 SCC 146 Krishan Yadav and Bharat Singh in support of his submissions. Having heard the respective counsel and having bestowed our serious consideration to various submissions and having gone through the impugned judgment, we feel that it will be appropriate to note the sum and substance of various submissions and find out whether there is any scope for interference with the judgment impugned in this case. The submissions of the learned counsel for the appellants can be noted as under. Stop.